Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender.
What you're about to witness is not just another routine courtroom exchange. This is a case where credibility, accountability, and personal responsibility collide in real time. We're dealing with a defendant who has already crossed a serious line inside the courtroom, spitting in open court, and now stands before Judge Simpson trying to regain trust. From the very first seconds, the tension is baked in. You have a public defender trying to stabilize a situation that is already volatile, a defendant eager to move forward, and a judge who has not forgotten what happened before. This is the kind of case where every word matters. Waiving rights, asking for drug court, talking about bond. These aren't technicalities. They determine whether someone walks out the front door or goes back into custody. And when a defendant says, "I'm trying to plead guilty and get out of here," that alone tells you something critical. He's focused on escape, not understanding. Courts don't move on impatience. They move on procedure. Judge Simpson is a judge who values control, order, and honesty. If you come into his courtroom thinking you can rush the process, talk your way around facts, or play loose with the truth, you're going to learn very quickly that this is not that room. This case will expose how fragile trust is once it's broken, and how hard it is to earn it back.
Go ahead and state your name. Sean Newcomb. Thank you. Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral for drug court. Okay. Oh, I'm sorry. No. I'm drug court. Yeah. Actually, I need somebody. No. We're going to waive this matter over. You're going to waive? I'm looking right at the waiver right now.
Sir, you're going to waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir. I'm trying to plead guilty at circuit court and get out of here. That's too much information.
I
rounded up to notes, Your Honor. Where I got it. Okay.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution?
Absolutely.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single count.
Thank you, Your Honor. We acknowledge receipt of information, waiver's reading in the record. My client was sending. Actually, I think he needs to sign that waiver. I didn't have to sign it.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30.
That's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue of bond?
Yes.
Your Honor, my client's bond is currently set, I believe, at $10,000 cash or surety.
It's 5,000 personal recognizance.
That got revoked, yeah. But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst the people.
Yes. Yes, I do recall. Yeah.
This is where the room shifts. The word saliva lands like a hammer. Everyone knows what it means. Spitting in court isn't just disrespect, it's dangerous. It's treated as an assault. It disrupts proceedings, exposes people to bodily fluids, and signals a total collapse of courtroom order. The defense tries to frame it as a past mistake, something that has dried up, something tied to competency issues. Judge Simpson cuts straight through that framing. I got a lot of people coming off competency issues that don't spit in my courtroom. That line is powerful because it draws a boundary. Mental struggle does not excuse endangering others. Courts operate on trust. When someone violates that trust in such a visceral way, the memory lingers. You don't get to reset the room just because time passed. The judge remembers. The staff remembers. The system remembers. And now the defense is asking for leniency, reduced bond, a second look. The tension here is real. Can the court see the person as he is now, or does the gravity of what he did outweigh any claims of improvement?
Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up, and my client was coming off competency issues.
He was what?
He was coming off competency issues.
I got a lot of people that are coming off competency issues that don't spit in my courtroom
Well, Your Honor,
on people.
he is very truly sorry for that. And he would like the court to know that.
I would like to
Again,
offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really, really odd for me to have done something like that.
Can we approach really quickly, Your Honor?
Why?
Well, if I say why, then I will need to approach. Approaching things.
I can just say no and it wouldn't matter, right? Yes, you may approach.
Your Honor,
Yes, go ahead.
okay. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a personal bond. We'd be happy if the court would consider $1,000 cash or surety, but he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have I had to stop court, come in, clean up after you. Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it ever.
Judge Simpson isn't speaking emotionally here. He's speaking institutionally. When he says, "I just don't tolerate it ever," he's defining a rule that transcends this one defendant. Courtrooms function because people believe the rules are absolute. Once you allow one person to violate them without consequence, you erode the authority of the entire system. The defendant responds with remorse. He sounds sincere. He says he realized immediately what he'd done. And that raises a hard truth. Remorse doesn't erase risk. Judges don't sentence feelings. They assess behavior patterns. This man didn't just make a mistake. He disrupted court operations, endangered people, and forced proceedings to stop. This is why bond is such a serious decision. It's not a reward. It's a risk calculation. The court must decide, can this person be trusted in the community while his case is pending? Judge Simpson denies the request, not out of spite, out of principle. Maybe Judge Conlin will feel differently, he says. That's not deflection, it's restraint. He's acknowledging limits while standing firm on his judgment.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlin, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper cause.
Yes, Your Honor.
I'll give you a date and moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today, along with
I do see you.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But, and I'm
not candid would be an understatement. I mean, he just outright lied.
well, I wasn't there.
That makes it no less a lie.
This is the core fracture in the case. Honesty. The judge isn't focused on drinking itself. He's focused on deception. Courts can work with addiction. They can work with relapse. What they cannot function with is a defendant who manipulates the truth. When the judge says, that makes it no less a lie, he's rejecting every soft excuse. Panic, confusion, pressure. None of that changes the fact that the court was misled. And in the legal system, lies carry weight because decisions are built on them. Bond conditions, treatment orders, release decisions, all of them depend on truthful information. If a defendant lies about alcohol use, the court may believe treatment is unnecessary. If he lies about being in treatment, the court may think progress is happening when it isn't. That's how people fall through cracks, and how harm happens later. This is why Judge Simpson sounds almost disappointed rather than angry. He's confronting a pattern, not a moment. The defendant now wants to apologize, but apologies without transparency are hollow in a courtroom. Ask yourself, if someone lies when the stakes are this high, what happens when no one is watching?
I'm asking if you want to hear from him. A humble apology.
I will certainly hear from him, but not if he's going to sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it was too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so did you have any O'Douls?
At first, but
At first. Okay. How many O'Douls did you have?
6.
6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay. Now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I told you.
No. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Douls. I told you to get to the levels that you were, if you were just drinking O'Douls, because you were insistent on that, you would have had to have a little over a case of O'Douls.
This exchange is surgical. Judge Simpson dismantles the lie using simple math. Blood alcohol levels don't lie. Biology doesn't lie. And when a defendant tries to use non-alcoholic beer as cover, the judge doesn't mock him. He proves him wrong. What's happening here is credibility collapse. Every correction compounds the damage. First, it was O'Douls. Then it became 2 beers. Now it's 6 and 4. The story keeps changing because it was never true. Judges remember patterns. And here, the pattern is avoidance. The defendant isn't lying to escape punishment. He's lying to avoid confronting himself. But the court cannot operate on self-protection. It operates on reality. This is why Judge Simpson says, I know a whole lot more than it appears that I know. That's not a threat. It's a reminder. Judges see thousands of cases. They recognize deflection. They recognize rationalization, and they know when someone is talking around the truth. This moment isn't about alcohol anymore. It's about whether this defendant can stand in front of authority and tell the truth even when it hurts.
Remember that?
Yes.
Then, at that point, you realize, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. It's trying to go to treatment.
Well, yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the last.
Did you or did you not tell me that you were in treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting. We're trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
I really don't.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
That line is devastating in its simplicity. No theatrics, no lecture, just cause and effect. Lie, and the system tightens. Lie, and trust evaporates. Lie, and freedom becomes conditional. Courts are one of the few places in life where dishonesty has immediate structural consequences. This defendant didn't just lose credibility, he lost options. Every future request will now be filtered through this moment. What makes this powerful is that Judge Simpson isn't angry. He's instructional. He's telling the defendant exactly how the world works inside this building. The rules are transparent. The outcomes are predictable. This is also a moment of opportunity. The judge is still talking, still explaining, still engaging. That means the door isn't closed, but it's heavy now, and it will not open easily again. For viewers, this is a mirror. How often do small lies feel harmless? How often do they snowball? In court, that process is accelerated. Consequences arrive in real time.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment?
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're working.
Oh, I know they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yep.
Anything from the people?
Your Honor, the people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. Now, we allege that we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
The prosecution's tone here is measured and strategic. They are not calling him a bad person. They are not asking for punishment. They are framing risk. And that's what bond decisions are about. Risk to the public, risk of reoffense, risk of non-compliance. They acknowledge the pastor's letter. They acknowledge the good, but they anchor the argument in reality. Untreated addiction is a predictor, not a moral flaw, a predictor. This is important. The system isn't saying you are broken. It's saying, without structure, this will happen again. And that aligns with everything the judge has already uncovered. Notice how no one argues that he deserves jail forever. They argue that freedom must be supervised. That's the difference between punishment and prevention. This is the moment where the court pivots from past behavior to future control. The question becomes, how do you release someone safely when trust has been damaged?
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to, first of all, adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a sober reason.
Correct.
You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up. You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, we'll do that. Okay. Thank you, sir.
Judge Simpson's ruling is precise and conditional. A $25,000 personal recognizance bond, a scram tether, 10 days to enroll in treatment, or a warrant issues. This is not leniency. This is structured accountability. The court is saying you may walk free, but only under constant supervision. Every sip of alcohol will be detected. Every delay will be punished. Freedom is no longer assumed. It is monitored. This case is a study in how courts balance humanity with protection. The judge didn't ignore the pastor. He didn't dismiss the family. He didn't deny the possibility of change, but he anchored every decision in behavior, not promises. The lesson here is clear. Courts can forgive mistakes. They can work with addiction. They can offer pathways forward, but they cannot operate on fiction. Truth is the currency of justice. This defendant now has a narrow path. Walk it honestly or return to custody. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.